So in this video, I have an update for you on the Texas Suppressor Freedom case, which aims to stop the NFA and ATS regulation of suppressors. Now, really quick before we jump into this video, I want to thank the sponsor of this video, which is Policy Genius. We here in the Second Amendment community take protecting others and ourselves very seriously. Policy Genius helps you find the proper insurance policy so that you are prepared for the worst case scenario. I personally saw how important it is to have a strong life insurance policy when, unfortunately, my dad passed away earlier than was expected. Life insurance, as many of you know, can be a critical stopgap to protect your loved ones if something goes wrong. Policy Genius has made it easy to compare the top life insurance policies, and they help you find the lowest priced and best price that actually fits you. With Policy Genius, you can find the right plan for you, and you can find life insurance policies that start at just $292 a year, and you can get up to $1 million in coverage. Some options offer some same-day approval, and you can even avoid the unnecessary medical exams, which I know is probably important for some people. Policy Genius works for you and not the insurance companies, and that's why they have thousands of 5-star reviews. So if you want to see what options are available to you, head over to Policy Genius. You can go to policygenius.com/armscholar to get your free life insurance quotes today. So thank you again to Policy Genius for sponsoring and supporting this two-way content. As I mentioned in the intro, in this video, we're going to be discussing the Texas Suppressor Freedom lawsuit, which aims to eliminate the NFA and ATS regulation of made in Texas suppressors. The ATF is now trying to get this case thrown out of the Fifth Circuit by arguing that any positive decision will essentially cause the improper circumvention of people like me and you paying a required NFA tax. The case we're going to be breaking down and discussing is called Paxton v. Dettelbach. This is an important and interesting case that was decided by a district court back in July on cross motions for summary judgment. Last July, the federal district court there issued an order granting the ATF's motion for a summary judgment because the judge there believed that the plaintiffs lacked standing to bring this lawsuit, so the case was thrown out. Also, the court found that the state of Texas cannot stand in the place of its residents to sue the government to stop the application of the NFA and the tax requirements against made in Texas suppressors. Texas then appealed that ruling up to the Fifth Circuit Court of Appeals, and right now the ATF is trying to argue that NFA taxes and those requirements essentially barred this case from proceeding forward in the Fifth Circuit, and ultimately that the Fifth Circuit should agree with the lower court, dismiss this case, and they even argue that the Fifth Circuit should not even hear oral arguments in this case. But now all of this is coming to a head, and the Fifth Circuit has rejected the argument that, hey, they should not hear oral arguments, and they are in fact going to have a hearing in this case, and it's going to take place the week of April 29th. So this is a significant case, something that is very significant moving forward in the Fifth Circuit and will have broad-reaching implications that we need to talk about. Now, for those not aware, this lawsuit arises out of Texas House Bill 957. HB 957 aimed to exempt from federal regulation all suppressors that are made in and remain within the state of Texas. The claim behind this specific law is that since these items are made and sold exclusively within the state of Texas, they do not fall under interstate commerce, and therefore they fall outside the purview and federal regulations of the ATF. Now, after Texas passed this law, the ATF then sent out letters threatening that they will in fact enforce the NFA and GCA's regulations against made in Texas suppressors. So again, keep that in mind. They are still going to enforce this despite what Texas has said in their law. In response, Texas, along with some individual plaintiffs, then filed a lawsuit against the government. This case was then submitted to a federal district court on cross motions for summary judgment. Well, after reviewing the case, the district court judge did in fact grant a motion for summary judgment in favor of the government, so the ATF won at the lower court level. The court ruled in favor of the government under the rationale that the plaintiffs here, the individual plaintiffs, along with the state of Texas, lack standing to bring this lawsuit. Standing has 3 basic requirements that must be met for a case to proceed forward. First, there must be a concrete injury in fact that is not just simply hypothetical. Second, there must be causation, or something that is fairly traceable, in a connection between a plaintiff's injury and then also the defendant who is being sued. And third and finally, there must be some sort of redressability. Essentially, that relief granted by the court can actually cure that injury. Now, on review, the judge here found that the plaintiffs have not suffered an injury in fact, and therefore they have no standing. The judge essentially stated that the individual plaintiffs would have to allege that they either possess an illegal silencer or that they have engaged in some other prohibited conduct that the ATF claims is illegal. He also then said that they may be able to cure their whole standing issue if they in fact went through the NFA process, if they filed the forms to make a homemade suppressor, if they went through the process, well, then maybe they could actually have standing. And that would, wouldn't matter whether or not they were approved or denied that made-in-Texas suppressor, just going through the process maybe could cure the standing issue. So in essence, the judge required the individuals to subject themselves to the unconstitutional process that they're actually challenging. Finally, the lower court found that Texas itself as a state also did not have standing to sue on behalf of their residents. Now, in response to that, Texas then did file an appeal up to the Fifth Circuit, and they're asking for the Fifth Circuit to review that granting of the summary judgment and essentially find that the lower court was incorrect. Recently, the ATF responded to this appeal and argued that under the Tax Anti-Injunction Act, or the AIA, this lawsuit was improper from the start, and essentially it would result in the avoidance of individuals paying a required tax under the NFA. So they're using taxes as a basis to claim that this lawsuit is invalid. The ATF claims that under the AIA, there is a specific process that you have to go through to bring a lawsuit like this. Essentially, they're saying this lawsuit was not through the proper channels. Under the AIA, the individuals here would have to go through the process. If they didn't like having to register or pay the tax, well, then they would take that up with the Attorney General. They would file a complaint for a refund from the Attorney General. If the Attorney General then decided not to grant a refund, well, then they could sue for the refund. But they're saying this generalized request and lawsuit against the ATF based on the made-in-Texas suppressor issue is not the proper channels. They have to go through the AIA, and this whole avoidance of an NFA tax bars this lawsuit. Then the ATF argues that the Second Amendment is not implicated at all when it comes to suppressors, and this is where the whole Second Amendment challenge comes in. They state that the Second Amendment's protection extends only to instruments that constitute bearable arms and that are typically possessed by law-abiding citizens for lawful purposes. Because the Second Amendment covers only bearable arms, laws that regulate firearms accessories or attachments do not necessarily implicate its protections. And a silencer is a firearm accessory. It's not a weapon itself. So this is the position that the ATF is taking. It's not a weapon itself. It's simply an accessory. And they claim that accessories, like suppressors, are not protected by the Second Amendment. That's also not acknowledging the fact that the ATF and federal regulations themselves and the NFA and GCA actually treat suppressors themselves as true firearms. They are regulated as actual firearms within their own right, but the ATF wants the court here and everyone else to forget that. Now, in response, Texas goes on to point out in their brief, and tearing down everything that the ATF said, they argue in their brief that the whole tax issue and the NFA tax requirement is not even at issue at the Fifth Circuit level. Really, what's all at issue here is whether or not the state of Texas and the individual plaintiffs had standing to bring this lawsuit. Texas argues that this issue is not before the court. The parties extensively briefed this issue below. Appellants noted that only one of their four claims implicated the Anti-Injunction Act, and the exceptions applied even to that claim. However, the district court did not rule on the Tax Anti-Injunction Act or even acknowledge the issue in its order of dismissal, nor was it required to. Instead, it decided only on standing, and only the injury in fact prong. The court should not consider the parties' Anti-Injunction Act arguments. The district court should consider them on remand. So again, they're pointing out the fact that this whole dispute, this whole appeal, is about whether or not the plaintiffs have standing, whether or not Texas has standing, and whether or not they have suffered an injury in fact, which is required for standing. That is what is being disputed, but the ATF wants to throw in all these other side issues to kind of sidestep what is really going on. And then when it comes to the Second Amendment arguments, Texas points out in their brief that because of the Supreme Court's 6-3 decision in Bruin, which struck down New York's concealed carry processing scheme, Texas and the plaintiffs do have standing to challenge the NFA's process itself. They argue that post-Bruin, whether citizens may challenge requirements to apply for permission to exercise Second Amendment rights is an open question. Although ATF cites these opinions as controlling authority from this court, it saves this argument for last, surely because it recognizes the shaky status of these opinions post-Bruin. Here, Texas is directly using the Bruin decision that was issued by the Supreme Court to point out that the post-Bruin, ideology and world is that states like Texas and plaintiffs that are involved in this case have the ability to challenge application processes that, serve as a barrier to the exercise of our right to keep and bear arms under the Second Amendment. That is exactly what is being challenged in this lawsuit. And therefore, the lower court dismissing this case for a lack of standing also directly violates what the Supreme Court said in Bruin. Oral arguments will in fact happen in this case, and right now the arguments are set tentatively to take place during the week of April 29th. I'm actually very excited to hear the arguments in this case because it's absurd, this whole NFA tax position that the ATF is making. They've also kind of brought that up in the whole pistol bracelet lawsuits, so that's going to be important as well. Of course, if anything else develops, if we get any more information, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.